My name is Rose Harvey-Sullivan and I am the mini pupillage secretary for Chambers. So I'm in charge of sorting out any mini pupillages that people come on and have some bits to do with the pupillage system as well. We are really pleased to be able to meet all of you virtually today. Throughout the evening, if you've got any questions for any of us or anything arises for anyone to talk, please just pop them in the chat. We're going to have a question section at the end where we will answer as many of them as we can do. So I think the lineup is for our head of pupillage, Adam Weitzman-Casey, to welcome all of you and to give you an overview of the pupillage system. So I will hand over to Adam to tell you a bit more about it. Thanks, Adam.
Thank you very much, Rose. Thank you for joining. As Rose says, I'm head of pupillage, so I'm just going to talk about the process a bit. I should start by saying we're going to have a number of speakers, including Jasmine, who was a pupil last year and joined us this year as one of our newest tenants. We are a multidisciplinary set, and so you're going to hear people talking who do very different practices, but it's something we pride ourselves on. And we think it's very important. We think it's important both because it means that we have a huge breadth of work in the set, but also it's important for people who are training because they get to experience more than one type of law. And we think that makes them better barristers. So although I am now a silk who practices predominantly in personal injury and clinical negligence, I was called in 1993 and did my pupillage starting in 1993. And I continued to practice in crime until 2009. And I'm sure that that breadth of experience has made me a better advocate. So we think it's important to have that breadth of practice. How do we run pupillage? We have a 3-stage process. We do a written application for Gateway. We do a first round interview when we interview 60 candidates by 2 members of Chambers. And then there is a third round interview where a panel of 5 members of Chambers interviews 12 candidates. The first round, the Gateway, the written application, we mark blind on names and universities. So they are blanked out. And we do that to try and ensure there's no unconscious bias. Obviously, when it comes to your later interviews, we will know which universities you've been to because it's very difficult to have a chat and discussion interview if that information isn't clear. But we mark blind in the first round of interviews. There is a legal problem, and I would stress it's really important that if you want to come here, you make an effort to research and answer the legal problem, because we consider it an important part of your application. What I would say is that when we mark the written applications, we look both at, obviously, academics, and those are important, but also life experience. So we're interested in people who bring difference and experience in working in other areas, the experience of working with people, because we consider being able to relate to people and having a certain amount of empathy with the kind of people we represent an important element. We obviously look kindly on those who have done many pupillages and mooting, but we don't exclude those who haven't. If you've done other forms of relevant experience, we'll look at that and take that into account. We'll also look at people who have acted giving pro bono legal advice, and we see that as an important element. So please don't think if you've had difficulties doing lots of mini pupillages or mooting, that means you'll be excluded. It doesn't. Second round interview, I'm afraid, and I know it's a burden because I know you've got lots of different application forms and interviews to go through, but there is another legal problem. We have 20 minutes. We ask you about your answer to the legal problem for 10 minutes, and then we spend 10 minutes asking general questions. Final round interview, we give you a proposition 10 minutes beforehand and ask you either to argue for or against for 10 minutes. And then again, there's a general discussion. Our pupillage award is 60,000, 50,000 that we pay you, some of which can be drawn down early, 10,000, which is from guaranteed earnings in the second 6 months when you're on your feet. You will have 3 pupil supervisors, each for 4 months. The first pupil supervisor will be civil, and that will take place in London. The second pupil supervisor will be crime, and you'll be travelling a lot, most likely out on the Midland circuit, going to court centres such as Nottingham, Birmingham, Leicester. And in the third 4 months, we'll try and find you a pupil supervisor who fits an area of practice that you're interested in. You will also do the first 8 months of family work, because in your second 6, you'll be doing civil, criminal and family on your feet. And Jasmine will tell you her experience of the last 6 months, but I think you'll find that our pupils in their second 6 are very busy in court. So we try and make sure that you see the full breadth of Chambers work, which includes civil, personal injury, clinical negligence, and some commercial, employment, crime, general and financial, family, private and public, and also inquests and inquiries. 2 other things to mention. When we come to tenancy selection, it's not a competition between pupils. If you're good enough and we think you would make a tenant who would flourish in these chambers, we'll make you an offer. Our view is it's not about how much work there is, it's about your talent, because a good barrister will drum up the work they need. And finally, it will be up to 3 pupils, and we will be selecting for 2024. Grace, I hope that is a whistle-stop tour of the process. Is there anything I've missed?
Adam, that's really helpful. I think one of the things that often comes up when I'm doing pupillage fairs and stuff is one, the question about, do you have to do mini pupillages? How crucial are they? So I'm glad that we've kind of addressed that, because we know lots of people are working full time or whatever, and they need to fit around that.
It's been difficult in the pandemic, so.
Yeah, absolutely. And if people have got caring responsibilities or kids or anything else, it's much harder to go along for a 2 or 3 day unpaid stint, isn't it? But so it's good to reiterate the point that we don't require people to have done mini pupillages if they can show those interests and commitment to the bar in other ways. It's really helpful, Adam. Thank you. I know you've got to get off home so that you can.
I've got to go and cook supper for the children, but I may join later in slightly different garb for the question.
Brilliant. Okay, so you'll be back for the Q&A. That's really helpful. Thank you, Adam.
Thank you, everyone. Bye.
I just wanted to sort of reiterate one of the points that Adam makes, which is that we have multidisciplinary practices often in our chambers, particularly at the junior end. I'm 7 years in now and have still quite a wide-ranging practice, albeit I've dropped quite a few of chambers' key areas, but certainly for the first 2 or 3 years, we all do quite a lot of different areas. And we tend to think that makes us better advocates, I think, because, law isn't all boxed in and, neat in that, it's only a family case or it's only an employment case or whatever. So I think it's really important to reiterate that one of the things we think you get from coming to our chambers is that kind of multidisciplinary approach, so you can cross the divides. And actually that means you tend to get more interesting work, I think, because they're the more complicated cases or the unexpected ones. And usually I think solicitors come to us for that reason. So really important to stress that, 1, we're a multidisciplinary set, and so you get to see all sorts. But 2, that will really help you in the longer term and in your practice to develop a more interesting sort of body of work, I think. Speaking of that, I think we've got Craig who's going to speak next. He is a pupil supervisor in Chambers, and he also does civil and inquest work. So he's here to tell us a little bit more about how his practice looks on a day-to-day basis. So Craig, shall I hand over to you?
Thank you, Rose.
Thanks.
And thanks to everyone for joining us this evening. Nice to see so many people on the call. As Rose was saying, I'm a civil practitioner. I'm also a pupil supervisor. And I'm going to talk a bit about my practice and also about what pupillage looks like when I have pupils assigned to me. By way of background, I joined Chambers as a pupil in 2005. And as Adam and Rose have already highlighted, I started and spent the first few years of my practice doing a bit of everything. But after a few years, started to focus more and more on civil work, and my practice now is predominantly clinical negligence on behalf of claimants, but I also do some more general personal injury work. I do quite a lot of historic abuse work, so acting on behalf of individuals who were physically or sexually abused as children and want to bring compensation claims against their abusers or the institutions where they were abused, and some kind of more general road traffic accident work and defending local authorities when people have accidents on potholes or want to bring claims because they've had accidents at work or stress at work or been beaten up at work. So a bit of a mixed bag, but mainly claimant clinical negligence. And as a civil practitioner, my practice is a mixture of some court work, some paperwork, and then lots of meetings, so conferences or settlement meetings. A high number of the cases that I do will ultimately settle. It's only a minority which go all the way to trial, particularly in medical negligence. So day to day, my workload might involve meetings with clients to advise them about the strength of the case, or to ask them questions about the case so that I can advise them on the issues and the strength, to advise them on the value, or meeting with experts. So particularly in clinical negligence cases, the expert evidence is crucial. So you can have a number of meetings, or we call them conferences, a number of conferences with your experts trying to understand the case and to put it on the best footing. Or once you've made sufficient progress in the case, a meeting with the other side's lawyers where you talk about the issues and see if you can try and resolve the claim by negotiation. And then so far as written work is concerned, that usually looks like written advices to the client and the solicitor, be it on a point of law or on the strength of the case, or drafting a skeleton argument for a hearing that might be coming up, or formal pleadings for court. And then in terms of court work, although, as I say, quite a lot of what I do does ultimately result in settlements, so it's only really the minority that go to trial, there will, in lots of my cases, be various hearings along the way, and that can be something which isn't particularly controversial, such as setting directions to hearings where there are quite profound disagreements and lengthy arguments on procedural points or legal issues, or where the other side are trying to strike you out or get some large part of your claim knocked out. And that will give rise, again, to skeleton arguments and other associated written work. So that's mainly what I do. It does bring me on to inquest work, which I was also asked to kind of cover in my section this evening. And there are some people in Chambers who I know are really inquest specialists and do quite a lot of inquest work and quite varied inquest work. For me, my inquest practice is really a subset of my medical work. And so, with one exception, over the past decade, every inquest that I have done has been an inquest involving somebody who has died as a result, we say, of the medical care that they received or lack of medical care. And for me, doing or being instructed to do an inquest, it's usually with a view thereafter to be pursuing a civil claim for compensation. And so it can be easy to look at the inquest as a stage in the civil claim, an important stage in the civil claim, because usually they're held quite early on, so not long after the death in question, and well before the civil claim has got underway. And so you can look at it as an opportunity to try and gather some evidence which might be helpful for your civil claim, and at the actual inquest hearing to put questions to the doctors and nurses involved in the claim, which might then be helpful. Involved in the care, which might then be helpful to your claim afterwards. But I think, and I always say to my clients, to look at an inquest just as a step in the civil litigation process, it is probably a mistake. And that's partly because of what I was saying earlier about the vast majority of clinical negligence claims ultimately settling. The inquest is usually the only opportunity that the family have to see the people who were involved in the care, to see them, as it were, in the flesh, to have their evidence tested and to have questions put to them, and for those professionals to be held to account. Because the reality is, once the inquest is done and further investigations are carried out, if the claim is a good one, it will probably settle, and if it's not, it probably won't go much further. So for the family, inquests are really important opportunity for you on their behalf to put the questions that they want answers to. And because it's held not long after death, I find that they can be really quite emotionally charged, both for the family members who are there and the professionals who have to come along and face questions from me on behalf of the family as to the decisions that they took and the care that they provided or didn't provide. The last two inquests that I did both involved the death of children. So one, which was an inquest I did just a couple of months ago, was a baby death case, and one I did last year was a girl who was about 12 years old. And it's really hard, obviously, not to be moved by those cases. And I think being there up the coalface can really, bring home both the privilege and the responsibility of the sort of work that we do. And it's really inspiring because not just the medical negligence work that I do, but everything that we do, it's often working for fairly ordinary people who've had their lives turned upside down, either by a death or by a life-changing injury. And it's not just the individual in question, it's not just the client, as it were, it's also the family. And it can be really inspiring to see how they respond to that, how they rally. So it's important work. And I think for anybody who is interested in doing medical negligence work or other personal injury work, there was a recent article in The Guardian that I saw involving the death of a 14-year-old called Martha. And she was a daughter of a Guardian editor, and she writes a long account of it's a case that involved allegations against the hospital, and she writes a really long account of everything that she went through and the issues with the hospital. And I read it not long after the inquest I was just talking about, and found it really moving, and it just really reminded me of lots of the cases that I do. So worth looking at, I guess, some of the issues that can crop up and the emotions it often engages. So that's the basic background of the work I do. So far as pupillage, I've been a pupil supervisor for about 6 years. I'm currently on my 4th pupil. On each occasion that I've had pupils, I've had them in the first 4 months, so in the non-practicing period, which means that the pupil is with me every day. Apart from when we were in the pandemic, the pupils are often in my room, and they come with me to everything I do. So if I'm in court, if I'm having a meeting, if I'm having a joint assessment meeting, the expectation is the pupil comes. They keep a note of everything that goes on. So be it a court hearing or a conference. I will, of course, give the pupil some papers in advance and get them to kind of jot out a plan of how they would approach the hearing or the meeting or the joint assessment meeting if it was their case, and that's something that we can discuss afterwards. And then the other kind of aspect of the work that I set pupils is paperwork. So I will invariably have lots of papers to do on my to-do list, and I'll select what looks like an interesting or useful piece of work for the pupil, get them to do it. And then once we have both done the piece of work, we'll both then sit down and look at each other's work and have a discussion about where we think each other went right and where each other went wrong. And I found with all the pupils, you get improvement over the 4 months, and that's really the idea of pupillage. It's just bringing people along so that they're ready at the end of the first 6 months to start doing work themselves, and at the end of the 12 months to start in independent practice. So I think that probably covers what I wanted to say, Rose, in about the time that I was going to say it. Unfortunately, like Adam, I can't stay on the line. I'm not going to go and cook dinner, but I'm going to go and carry on watching Frozen the musical with my daughter. But if there are any questions which are specific to me, I know that we've got a great panel, so I'm sure they'll be able to deal with any questions that people have. But if there's anything specific to me, let Chrissy know and she can email that on to me.
Brilliant. Thanks so much, Craig. I mean, I don't know, before you leave, one of the things that struck, because I obviously do inquest work as well, mine's probably more mental health and disability related than yours, but I think same sorts of principles in terms of the emotionally charged kind of, it can be quite heavy and it can be quite difficult, especially representing families, albeit I find very satisfying. Yeah. But I think one of the things that I have enjoyed in our chambers is that we're all quite supportive of one another. So if I've had a really tough day, I can come home, come back to chambers and maybe go for a drink with some whoever's in the building or whatever, things like that. I find that a really useful way to deal with those things. But presumably you work in a different bit of the building than me, but I suppose there's a similar sort of, approach from your end, is there? Yeah, absolutely. And I think Chambers is a really great community. Obviously we are big, so you will always find people in Chambers. I think it's difficult because I've not been in another Chambers, but I think we're a really friendly bunch. And I think lots of people who have come to us from other chambers who come and do work experience with us say the same thing. And certainly in my section of the building, so there's a corridor with a bunch of rooms, there's a really great community and people who get on and who are really supportive. So yeah, it's a really, I think it's a fantastic asset that we've got, that we are, also terribly nice. Well, you can put it that way, yeah, sure. Anyway, listen, we won't keep you from Frozen anymore. Sounds like you're up for a... Well,
I wish you could, but yeah, promises.
All right, thanks so much, Craig. Nice to see you.
All right, nice to see you all. Good luck, everyone. Bye.
So yeah, as Craig says, if anyone's got a specific question for him about his work or his sort of view of things in Chambers, he's very happy to answer anything extra. Just let us know and we can kind of pass on a message. But yeah, lots of us will be.
Sorry, just before I do go, I can see that there is a specific question which has been directed to me, I think. Or it says hi, Craig. So I will deal with that.
Previous medical knowledge and how do you question doctors and nurses in a medical inquest?
That's a really good question. I'll try not to take up too much.
Before you answer it, let me just tell everybody on the link what the question is. I think
sorry,
if you haven't seen it. So Hannah, I think, has asked. Hi, Hannah. Hannah's asked, did you have any previous medical knowledge or expertise before practicing in medical negligence? And she wants to know, for example, how you would question doctors or nurses or carers, anyone working in healthcare, essentially, at a medical inquest.
So the first question, no, I didn't have any previous medical knowledge or expertise. Well, that's not quite accurate. I didn't have any medical knowledge or expertise before I started practicing as a barrister. Before I did medical negligence, I did more general personal injury. And so in the course of doing personal injury, because of course you're dealing with injuries, you start reading medical reports, reading medical records. And it will start just with, for instance, when I was very junior, doing a road traffic accident and whiplash. And so you begin to develop familiarity with medical terms and conditions. And then when I started doing medical negligence cases. They were relatively small cases. And again, you develop your body of expertise. And in medical negligence cases, as I was saying earlier, we rely really heavily on expert reports, and you're having conferences with experts. So you're discussing these things, and anything that you're unsure about, you will ask your medical experts. And as the years go by, you become more familiar with medical terms, but you don't need to have any prior medical knowledge, is the answer to that question. As to asking doctors, nurses, carers in a medical inquest, it's an interesting question for this reason. When you're doing a clinical negligence case, you will not get to trial without having your own expert evidence. So you will know from your own experts what the issues are, what the areas of questioning should be for the other side's clinicians. When you are doing an inquest, often you can end up rolling into an inquest before you've got your own expert report. So it can be a bit more challenging if you're turning up, for instance, at an inquest, which is all about, for argument's sake, cardiology, and you're asking a consultant cardiologist all these questions without necessarily knowing what the issues are. But with experience, you get more of an instinct for that. And I mean, it's a bit more, I wouldn't say winging it, but you're letting the answers shape your subsequent questions. So it's not quite perhaps as methodical as it might be where you do have a body of expert evidence.
Yeah, I think that's certainly my experience of inquests. I remember in the first two thinking, what on earth am I doing asking the doctors questions without my own experts? Because especially when you're starting out, you might be doing them pro bono. We do a lot of work with Inquest, the charity who Jasmine used to work for, things like that. Because and in those situations, especially if you're pro bono or it's not a medical inquest with a CFA attached, you might not have your own expert that you can go and ask questions of. Tap up any resources you've got in terms of mates who might be doctors or nurses or anything like that. Definitely, Hannah, just to get you started. Google will be your friend, early doors. But, it does come with practice, and you do find yourself falling into familiar patterns. And when you've got a body of expert reports from the first few cases you've done, sometimes you can kind of look back at those and think, okay, well, that's that point. And look, that doctor did a really good job of explaining the anatomy of this bit here or how that condition works. You can kind of draw on all of that old stuff and pull it in, and that turns out to be quite a useful resource as well, I find. But yeah, otherwise, absolutely agree with what Craig says, but relieved to know we all feel a little bit like we're winging it on that front. Thanks again, Craig.
All right. Thank you.
Take care. Bye.
Bye.
All right, brilliant. So, Hannah, thanks for the question. I'm glad we managed to get him to answer it before he left. We have now got Gareth Wheatman and Kat Shields, who are going to talk about criminal law and life on the circuit. So they are both out on the Midlands circuit at the moment, proving the point that that's what you go and do. Kat is Gaz's junior in the trial that they're doing at the moment. I'm sure they'll tell you a little bit more about it. And Gareth is also a pupil supervisor, and Kat was one of his pupils. So I'm sure they'll have lots of things they can tell you about pupillage and life in chambers. So I'll hand over to them. Thanks, guys.
Good evening. Hello. And indeed, Rose, thank you. Rose being one of my former pupils as well. Greetings, everyone, from not so sunny Gloucester now. Kat and I, as you've heard, are week 2 into a 5 to 6 week fraud prosecution, which we're working together as the prosecution team. So we are peculiarly well placed to speak to you this evening about not just crime in our chambers, but also life on circuit. A quick bit about me, and Kat will tell you about herself in a minute as well. I can't believe it, but it's a mathematical fact. I was called 23 years ago now. And so the last millennium just. I chose chambers because even in the 90s, people were predicting the death of the criminal bar, and it's got more challenging since then. But one of the great attractions to me then, and it remains now about 7BR, as you've heard already, and you'll hear some more in the next few minutes, we are a very broad church. We do a whole range of legal areas. A lot of them have overlaps with each other. And we go all around the country and across the world with the work that we do. And even younger me in the 90s saw that although my heart was primarily in doing criminal work, even then I realized there was a real value to learning the trade in other areas of law. So back then I did a 6 months personal injury, then 6 months crime. And I'm pleased to say that I've kept the personal injury work going for over 2 decades now. Crime is my main work, but the great thing about chambers is the clerk system and the member system is set up to support the exact mix that you want. So I will have maybe 1 or 2 personal injury cases on the go at one particular time. Usually there'll be an overlap with crime. So as you've heard already a bit from Craig, there's a lot of litigation involved in cases where there has been sexual abuse, and either institutions are being held to account for that in the civil courts, or indeed individuals who have been convicted in the criminal courts are then being sued in the civil courts for compensation. And I have a crossover practice. So it complements each other very well. But primarily my work is in crime, and it's not unusual as you find me and Kat this evening here in Gloucester. Can I point out, by the way, this is not my house. This is not Kat's house. I wouldn't have this thing on the wall. It's a nice, slightly weird, independent rental with big Georgian windows, which is why we're here now. But it's very comfy. A downside of what we call life on circuit, as you've heard already, if you're doing a big trial sufficiently far away from where you live, if that happens to be London or anywhere else, often when you're busy in the court day, you're going to end up staying up. And that's what Kat and I have been doing for the last week or so, which of course can be a downside if you've got friends and family at home that you'd frankly be missing by being away. But then again, the big upside of life on circuit, and one of the reasons that Chambers doesn't just say, as many criminal chambers do, of course, many criminal chambers say, oh, we don't really go outside the M25 because we're really quite very important. We've always said we go much further afield. And that's not because we're masochists, but it's a fact. When you think back over the most significant criminal cases in the last 20 to 30 years, the majority of them didn't happen inside the M25. And it's a fact that some of the biggest and largest cases happen all over the country. And certainly what you'll find if you compare yourself as 1 year call, 3 years call, to one of your colleagues who are pure criminal London practitioners, yes, they will rarely go outside the M25. They will go outside the M25 on occasion because all solicitors will collect briefs all over the country. But what the junior practitioners in pure crime sets that only do London work will find is they spend many years in the magistrate's court, doing the hard yards, small hearings, very, very poorly paid hearings, small trials, and the like. I'm not going to suggest to you for a minute we don't have to show our face in the magistrate's court, but very quickly, as I'm sure other members, I'm sure Kat will say as well, very quickly in our chambers, we get our brand new pupils and our junior tenants into the Crown Court, doing in their own right trials, jury trials, and then really importantly, we have a lot of cases where there are 2 members of chambers working on them, the biggest and most complex cases. And one of the things I really enjoyed, and I'm doing it again over these few weeks, is those I've worked with, Rose included as my pupils, we can then work together again on larger cases. And of course, one of the reasons you come to the criminal bar is to do the larger cases, to work with other colleagues and members of chambers, because they're the most challenging and the most interesting to do. So yes, there was an element of downside that you do a lot of travel, but there's a massive upside as well in that you get a huge array of the most serious cases to do. And also, the last 2 or 3 years has been very challenging for everybody. There is a big silver lining, though, in the criminal courts. I used to think for many, many years, it was madness that we would travel across the country for a 5-minute hearing where nothing really of any consequence happened. Well, the courts were dragged almost overnight into having to arrange video link hearings, both in the Crown courts and in the civil and family courts. And the Crown courts have got really quite good at doing that now. So, for example, tomorrow I will be standing up in front of the jury here in Gloucester. 15 minutes before that, I will be magically appearing in Nottingham Crown Court for a 5-minute straightforward application. In the old days, I wouldn't have been able to do that. We would have had to ask one of our most junior members to go up to Nottingham for that 5-minute hearing. Not good for anyone. Well, now it will all happen by video. And it also means that the work that the juniors are doing will only mean them sitting at their desk, sometimes with their wig and gown on, and appearing at that short criminal hearing. And the great thing about our chambers is that then new members, pupils, will also have then other civil paperwork to do, personal injury work, employment work. And instead of being on an East Midlands train all day, as used to happen in the old days, now they'll have much more time to get cracking with the work. Now, and I would say this because I joined 7BR as a pupil in 1999, and I've been very happy there for over 2 decades since. But although our geographical reach does have some challenges in terms of time occasionally spent away from home, there are huge benefits about it as well. Anyway, I've yabbered on enough. I'll stop talking. Kat, over to you.
Hello, everybody. From Gloucester. I'm Kat, and I am about 5 years into my time at 7BR. I joined as a pupil in 2017. Craig was my first pupil supervisor, and Gareth was my second. I also had a third supervisor in an area of law of my choosing. So my third area was employment, and indeed now I have a mixed practice between crime, employment, and personal injury. I would say I probably do about 70% crime now. And as you've heard from Gareth, we are currently working on a big case together here. One of the great things about 7BR, and as you've already heard from Gareth, is that when you have had a pupil supervisor and you have got to know each other well and you know how you each work, you can then work together in the future on longer cases. So I think this is our third big trial together. And we're used to it now and we know how we work together. And it's one of the big benefits of being led in a case as a junior, that you're not alone when you're out on circuit, because this can be quite a lonely job a lot of the time, especially if you're travelling out to do hearings, you're doing trials out on the circuit, you can be alone. But one of the massive benefits of this Chambers is that there are lots of opportunities for led work and a great kind of collegiate sense of working on longer cases. I was led in a criminal case within 18 months of my pupillage, which is an incredible opportunity and not something that you would get necessarily in a Chambers which only focuses on work within London. So there are massive upsides to joining a Chambers which has a busy circuit practice. I also did quite a lot of Crown Court hearings in my second six as a pupil. Whereas many of my colleagues who stayed within London during their pupillages were in the Magistrates' Court for the whole time when they were doing their criminal work. So you have a lot of opportunities that others may not have if you're willing to travel and go out on circuit. You've heard about the downsides potentially of being alone and staying on circuit for chunks of time, but ultimately we are self-employed and it is what you make it. You can carve a practice of your choosing, and at 7BR you can do it from day one. We have very supportive clerks who will listen to what you like to do and what you don't like to do and help you to shape your practice day to day. So, for example, I took a very long summer holiday this year because I'm self-employed and I can do that. I also do the areas of work now at 5 years in that I enjoy doing. So crime, probably about 70% of my time, and then a bit of employment and a bit of personal injury. I'm not often in Chambers because so much of my work is out on circuit. But as you've heard from a couple of others, this is a very, very friendly Chambers. And there is always somebody in the building and there's always somebody to chat to when you do go into Chambers. And there's always somebody to call as well. I have made many a late night call to more senior members of Chambers with urgent questions, urgent problems, something's happened at court. There's always somebody there to talk to you. And that was the case even as a pupil. I was always encouraged just to be open about anything I had on my mind, anything I needed to talk through. And I've always been massively supported. So I hope that's a useful whirlwind tour of what I've been up to recently and in the last few years in Chambers. I can see we've got a few questions, Gareth, so shall we have a look at them?
Let me just add one more thing I forgot to say as well, that although historically we were based in and around Midland Circuit, like a lot of nationwide larger criminal chambers, a large amount of our work is actually in the M25. So although I've been taking the mickey out of chambers that only go in the M25, a lot of our work is within it. So I spent 4 months prosecuting a complex drugs supply case in London, Greater London, earlier this year. We have a lot of our senior members in the Bailey, and then Southwark as well, doing fraud cases. So certainly there is the option as well there to focus your work on the more mainstream Central London course. Let's click on the chat box of Destiny now and see what the questions are. Let's just, here we go. There's a number coming in here. Gareth, could you please discuss what a tenant can expect to make on an average year after costs, rent, insurance, overheads, after pupillage, if they were doing criminal cases? I ask this because with high inflation, paying for families, we all agree with you on that. And that's a fair enough question because, let's be frank, all the figures we saw from the Criminal Bar Association were very depressing reading. The average income of a junior criminal barrister in the low thousands, not going up with inflation, and that is unsustainable in London. Here's the good news, and it comes back to the point that I made a short while ago, which is that because we focus on the larger cases, on the Crown Court cases, then it is possible in our chambers to get up to a much higher income in the early years. And Kat will correct me if I'm wrong, because the Kat is closer to that position than where I am now. Putting it bluntly, the way that one can command a much healthier criminal fees income is by doing the larger cases where there are two counsel, which commonly would put you, after a few years' call, above six figures overall earnings a year. Now, that's before then you pay tax to the government, before you pay your slice to Chambers. So I don't want to put an overly rosy picture. But again, another big upside of going further afield, doing the larger cases, is that is where, once you have the automated payment system, which is number of days of trial, severity of charges, number of pages, when all those calculations are done, I'm not going to suggest for a minute it compares to someone who goes down to the square mile and does commercial work. Of course it doesn't. But when you factor in the rewards of doing criminal work and how important it is, it is certainly not as gloomy as it is for the vast majority of criminal practitioners in the country. I'm not going to give you, Sarvesh, pounds and pence, because everyone is different, but it's another upside to coming to us because of the seniority of the work we do. Kat, is there anything you want to add?
I would just, I would echo everything Gareth said, and just to say, I'm very junior, but I've never had financial worries. You may have heard the horror stories about people having to call upon family to help them because of the nature of criminal work. That's not been my experience with the types of work that I do. But it was a reality in my choice of where I wanted to do pupillage. I knew I wanted to do criminal work. I knew I wanted to do employment work. But the financial reality of doing a pure crime pupillage was not attractive to me. And that's part of the reason why I chose to do a mixed pupillage, because I knew that my finances would be healthy starting off and in the junior years.
Yes.
Guys, I know there are more questions for you two. Because we've got some people who will need to leave for childcare stuff. Can I ask that we deal with them at the end?
Absolutely, yes, certainly. Criminal barristers always over-talk.
They just love an audience. It's an absolute nightmare seeing girls.
I now make 6 points. But yes, we'll come back. We'll be back on the link. We just have to nip out, and we'll be back on the link in a few minutes. Thank you.
Yeah, cheers. See you in a bit. Thanks, guys. Right, so you can see how chipper they are, despite the fact that they're up in Gloucester, ready to come back and answer more questions. But before we come back to hearing from them, we're going to hear from Anita Guha, who is one of our senior family practitioners, and also our senior practice manager for family law, Harry Smith. So it's what was traditionally called a clerk, and what we now call in Chambers practice managers. And Harry joined Chambers a little bit more recently, but they're going to talk about family law, and Anita will give you a flavour of her work in that sense. And they're also going to talk about the relationship between clerks or practice managers and barristers, and how that can really help. Having that good relationship can really help you enhance your practice and make the most of it. And also, it's another way to have nice colleagues, isn't it? So, guys, I'll hand over to you. Thanks very much.
Thank you.
Thanks, Rose. Hi, everyone. My name's Nita. I've been practicing family law for over 20 years. I came to 7 Bedford Row about 11, 12 years ago after being in another set of chambers. So I have experience of being in different sets. I used to practice in immigration and refugee law as well in the first 8 years of my practice. But now I specialise in all areas of children law, and including private law cases, which are cases between two individuals where there's some sort of dispute about where the child lives, and the arrangements in respect of contact, for example. And it also extends to care cases where the state intervenes and says that the child needs to be removed from the parents. And I often say that those sorts of cases are the opposite side of the coin to criminal cases involving children, because where, for example, there are charges of murder or child cruelty and neglect, or where there's a fatality or a non-accidental injury, we're having the same trial in respect of causation of the injuries, often with the same experts from the same disciplines being called, but you have obviously a different standard of proof. And you're focusing in the family case about whether the children can stay in the care of their parents or whether there's any prospect of rehabilitation. I also have a particular specialisation in international family law, which includes abduction cases, There's a treaty called the 1980 Hague Convention, which we're a signatory to. There are also non-Hague cases, wardship cases. I deal with honour-based violence cases, stranded spouse cases. So there's a wide breadth of variety, as you can see in family law. And it's simply not about, for example, how often little Johnny gets to see his father or his mother each week. And it is a fascinating and rewarding field with lots of variety. In Chambers, we have family is probably one of the smaller teams, but I think, Harry, are we up to about 20?
Yeah, I think we're 25 at the moment, with hopefully room to expand. And yeah, it's a bit of a building project it's been for us, hasn't it? Sort of get into certain areas. And yeah, we was ranked, wasn't we, this year for the first time. And I think, yeah, all down to the brilliant members that work here. And
I'm purely family, but that 25 will include a lot of mixed practitioners as well. And I think some people such as Rose have probably already spoken about how having that complement works well for a lot of our juniors. And, you know, what I think, having come from another set, is that what 7BR has to offer over and above other sets is having that common law discipline, which is a huge advantage to any junior barrister, because the more that you're exposed to in the long run, it's going to all contribute to you being a more agile and well-rounded barrister. Because back in the day, everyone was a common law practitioner and was able to pick up any brief. That probably isn't possible these days because of the levels of specialism that we have. But I think 7BR is living proof that a number of people have successful mixed practices. So moving on to the relationship that we've developed in Chambers with our clerks, I think we're very lucky at 7 Bedford Row because we are a smaller team as opposed to some of the big family sets which have 70, 80 family law practitioners. One of the advantages is that you're able to have a much more bespoke practice. And I think luckily we're not one of those sets where Harry's ringing me up and telling me at 5 o'clock that I have to go to Newcastle to do a 5-day trial.
We can't mislead. That has once or twice happened. Let's be real.
I was ready to turn my camera off then when you started that.
But well, I think those experiences are quite rare, and but yeah, something exceptional will have had to have happened for a phone call like that to have happened. But in my previous set, I mean, it's that was a frequent occurrence, because when you're servicing a number of solicitors on that level, and sometimes briefs have to be covered, but that is one of the advantages that we have. And I think I have an excellent relationship with the clerks. Put Harry on the spot now, because it's one where, you know, it's founded on mutual respect, where we have open communication, open dialogue. If there's any sort of issues, we can just talk it through. And I've never found that there's been any particular difficulties. What do you think, Harry?
Do you know what? If I'm honest, I've not been paid to say this, anyone, before you think that. I'm very lucky to be here with the members that are here, not only just the family ones, but across the board. There's a great team. I came from a specialist family set, or there for around 10 years. And I joined here just before Christmas last year. And yeah, one of the best things I've done, I think what Anita said is very accurate. The relationship that you have between the clerks, the staff, everyone at Chambers and the barristers is key. And I think we're lucky here that we all have the same drive to try and be the best we can be as a Chambers, and then as barristers as individuals. And that just helps us all just tick over nicely. And it's just, a very nice environment. I think as a clerk, you probably would get barristers maybe at their worst times when, things are going wrong, there's busy diaries and things. But across the board, I couldn't say I've had a bad experience with anyone in the last year. So whether I've just been very lucky, I'm not sure. But it's just a very nice place to work. And I think with us being a little bit smaller than some of the larger, maybe specialist sets, what Anita said, right, we have that better relationship. It gives me a chance to have better knowledge of the diaries and maybe try and tailor to people's preferences in work within not just family, but also, I get to learn a bit about civil, a bit about crime, which can be quite interesting as well. And it's off the back of all that, I think it makes all of us better, actually, but certainly me. I've been lucky to grow a lot in the last year whilst working here. So,
one thing, Harry, how do you find it with the fact that some of us do, because obviously, I do family work, well, not obvious, I do family work, but I also do inquests and some clean neg stuff and quite a lot of mental health and court protection work. So kind of a variety, but one thing I have found from the clerks is that obviously having those really open dialogues is really important for being able to fit all those things in, because some of those types of work get booked in weeks or months in advance. Some of it goes in the day before. Some of it, needs to fit around other bits, or if I need paperwork time or whatever. But from your perspective, how do you find managing members where we have those kind of varied diaries? Is that something that, does it make it harder? I don't know.
It made it more interesting at first because I didn't like to do that. So I had to learn to share, which I didn't like to do very often. But I think now, once you get to grips with understanding the other areas and, like you say, the different demands in terms of time frames, and family, for example, can be quite prepared. We can know a lot more about the cases in advance.
Yeah.
Well, I know it's not the same for every practice area. That still doesn't mean we don't get sort of urgent ex partes and things like that, which will be for the next day. But I think across the board as a whole, it's a little bit more ahead of time. So it's just something you learn. And between all of you, I think everyone's pretty happy to pick up the phone and let us know as clerks time frames and what we have to work with just to manage situations better. And I think we're getting better as a whole in the clerks team as well, just to make sure everyone's practices run as smooth as possible.
Yeah, I definitely appreciate just being able to kind of send you a text or pick up the phone and have a chat. It makes it feel a lot more relaxed from my end, but I don't know. Anita probably would feel the same. Anita, I was just wondering, because I didn't actually know you did other work other than family initially. Why did you pick family stuff over the other side of your practice, the immigration side?
At that stage, it was an extraordinary busy time at the bar. We're now in that climate again where there's an extraordinary volume of work, and I think most of us are extremely busy. But it did dip, and so the flow of work is not always constant in your career. And at that time, it was I was in court 5 days a week, and when you're doing back-to-back cases and coming back, and you've got a new asylum case for the next day, the bundle hasn't been put together properly by the solicitors. You need to do that. You need to draft a skeleton argument. The issues concerned are fairly serious in asylum cases. It just became quite oppressive trying to keep up 2 areas of work of that intensity. So that's why I backed away. And sometimes I do actually regret that. But I think these days, people probably try to take a bit more control over their practice if you've got the luxury of doing that in terms of your financial earnings. But I think, a lot of us just went in blind and just did whatever came our way, and you just keep on working and don't say no. But that's, an early lesson that you have to learn at the beginning of your practice. I also do some court of protection work, but I think I've generally found with branching off into areas such as international family law, and also I'm a special advocate, so I do some national security cases. That gives me the variety, and also I've had the opportunity at 7BR of having been involved in cases where there was an overlap with a discrimination case, where I co-worked a case with a number of members of chambers So that provided great opportunities. We're getting some questions in the chat.
Are we? Sorry,
about,
I distracted. Sorry, everyone.
Firstly, is there the opportunity to do much public law work? Okay, sorry, I thought that was public law as in family, but I assume that means.
I think that's a general question. Can we? I can see that's from Cher. Cher, we'll come to that at the end if that's okay. If anyone, I think Anita's got to leave. If there's any specific questions for Anita, whack them in the chat now. I can see there's something from Gloria about parental leave. Again, we'll address that, but probably at the end if that's okay, just so we can keep all the questions and keep a kind of vague idea on where we are. But if anyone has questions for Anita and they're not sharing them now, feel free to put them in. I'm sure, like Craig, Anita will be happy to respond to anything that's specifically for her if you send them in to Chrissy. Here we go. Here's one for you, Anita. Anjame would like to know, what interested you in family law in the first place?
Well, the honest answer is when I decided to become a barrister at university, after doing a mini pupillage and after having done some vacation placements for solicitors, I thought I wanted to practice in clinical negligence. But then I realised, going to a common law set, that there wasn't much court work in clin neg, and I was then exposed to family law. And I would say that there's a distinction between the very much people-based areas of law, which are family crime and employment, and then all the other areas, which obviously have their individual attractions. And I fell into family law. It found me. I can't really explain it better than that. That's
common, isn't it? That it kind of you, especially if you're doing a mix at the start. If there's an area that kind of really plays to your strengths, often you just find that you're getting more work from solicitors in that area because cases go well and you do a good job, and it snowballs a little bit, I think. So that probably happened to you, Anita, because I've seen you in court and you are good.
Well, thank you. I think I should leave on that note.
Yeah. Thank you so much for coming. I know I can see you're still in chambers, so thanks for staying around till 7 to do this. We really appreciate your time.
Okay, thanks everybody. Good luck.
Bye. Brilliant. All right. So we're now going to hear from Jasmine, who is one of the newest tenants in Chambers. She's just been taken on after pupillage. So she's going to talk to you guys about what it's like being a pupil in Chambers and a bit of a week in the life.
Hi everyone. It's funny actually, Anita was my family supervisor. So she was the last supervisor that I had before I was taken on as a tenant. So it's quite interesting to hear about the early days of her practice, because obviously I've been seeing her recently and a lot in the Royal Courts of Justice and didn't know a lot about that. So that's very interesting. I was just taken on in, I think October. It feels like it was a minute ago and also a month ago. And it's been a bit of a whirlwind since. The way that it works, and I know that some of this has been addressed already, is that you do 3 seats, and that starts with your 4 months of civil. You then do 4 months of criminal, and then after that you get the opportunity to pick an area. And as I just mentioned, I picked family and was supervised by Anita. For the first 4 months, obviously that forms part of your first 6, so you're not on your feet yet and you're not in court. So it's a lot of shadowing your supervisor, things like paperwork, that can sometimes be having you look at papers, and then maybe you might do some of the activities that Craig mentioned earlier on. So you might maybe prepare an agenda for a JSM. So you might prepare materials for your supervisor, or it might be an opportunity for you to try and have a go at doing something yourself. And that can be really interesting, also a bit nerve-wracking, because you do something and then you give it to your supervisor and they say, oh, this bit's very good, this bit, think about that again. And it's a really good way of getting a lot of those issues out and having someone supportive look over it for you and point you in the right direction. I did a lot of clinical negligence in my civil seat. And so what I found is that it was an awful lot of Googling of medical terms, which I think was touched on earlier on. So my Google search history took a real hit really quickly. And I think the first case that I was asked to look at for my supervisor was a particularly grim one. And so if anyone ends up doing clin neg, what I would say is be very careful about your Google searches and your images, and just make sure that you maybe run it past someone before you start Googling it on your work laptop. But I did a lot of that. So a lot of clinical negligence for my first 4 months. And then there's a very interesting period when you hit your criminal seat, because the first 2 months you're still in your first 6, so you're not taking on work on your feet yourself. And then the second 2 months of your second seat, if that makes sense, are the first 2 months of your second 6. So you still have your criminal supervisor, but all of a sudden you're in court and you're on your feet and you're doing work yourself. And that's a really interesting time, because the first 2 months of that, I was with a man called Dan Bishop, who mostly prosecutes, and he does a lot of Midland Circuit work. So what you've been hearing about circuit work is all absolutely what my experience was. And what I would say about that as a pupil is it's very exciting, because you get to see what your supervisor does. But at the same time, my experience of being on circuit and being in places like Lincoln quite a lot, or Leicester or Nottingham, was that obviously there's quite a bit of train travel, but at the same time, there's quite a nice atmosphere to it. And I shadowed my supervisor Dan for 3 weeks in a big drugs conspiracy in Lincoln, which meant staying up in Lincoln for a fair bit. And I think we did a couple of good pub quizzes. We went out for dinner. There's got some great tapas places in Lincoln, and you really get used to the place, and it's actually a really nice experience. And you spend a lot of time with your supervisor, learning from them, and not just seeing them in court, but seeing them in the roving room before or after, and hearing about how they sort of thrash out issues with their opponent, or how they talk to other people in the case, and that's really helpful. I then had my first 2 months. The latter 2 months of my second seat, which were the first 2 months of my time on my feet. And suddenly you start noticing things going into your diary, and it's all very exciting. And I think maybe Kat mentioned earlier on that actually as a pupil, I expected that it would be sort of non-stop bail applications, which you do a lot of on the BPTC. I felt like it would just be, I'd spend 6 months just doing bail applications all the time. And actually that never happened. I was straight in the Crown Court. I was doing straight away prosecuting probation breaches, doing PTPHs, doing mentions on pretty serious cases, as well as doing magistrates' trials and lists of trials and all that sort of stuff. So the work that you're doing, or that I was doing from day one, felt like work that I wasn't expecting to be doing. It felt like I was doing more complicated work than that, and that was really exciting. It also felt like I wasn't ever being asked to do something that the person asking me didn't think that I could do. So if I was being asked to do it, it was because someone thought that I was capable of doing it and had faith in me to do it, and I was supported to do it, which is very reassuring when you're first on your feet, because everything is new and everything feels a bit scary and a bit daunting, and you suddenly forget anything you've ever learnt, and you have to pick up the phone to everyone you've ever met and ask them for help. And the nice thing about 7BR is that everyone does pick up the phone to you, and that's definitely the case now, and it sounds like I can expect that to be the case for a good number of years yet. But what I found was that, especially in those first few weeks where I wanted to run everything by everyone was really supportive. You then have your last 4 months, which is your last seat, and I did mine in family, supervised by Anita. And by that point, your diary is extremely busy. So I was, by that point, in court pretty much every day. Sometimes, as Gaz was mentioning earlier on, you could be in court physically in one city, CVPing into another court in another city. There were a couple of days where I hopped between. I got on a train from one hearing in the morning to another train in the afternoon, but thankfully that wasn't all that often. Other times you might do a couple of CVP hearings in a day, and it's really nice to be able to balance your practice where you're in court, where you learn a lot, especially, as I say, in the roving rooms, for example, and also be able to fill in your diary and fill in your days with CVP hearings where you don't have to trek up to Nottingham, simply stand in court and say, oh, we'd like a different date, please. And then you go home again. So it's nice to be able to have CVP to do that. But what that meant is by your final seat, you're really juggling, sort of making sure that you see enough of your supervisor so that you know that area of law particularly well. And also managing, by that point, you're really starting to learn how to manage your own diary and how long things might take, and how to get some time in for paperwork and things like that. So it's definitely the expectation as a pupil that you will do a mix of areas. I do civil, criminal and family. And in fact, I did a criminal hearing yesterday. I spent today on a piece of contract advice to do with driving competitions. And then this afternoon, I've been looking at a child arrangements order, which is a family law order that I'm doing tomorrow. So it's very much the case that it's busy and you do a bit of everything. And when I do criminal stuff, I mostly prosecute. And again, in that case, I was put forward very quickly to do your CPS grade 1, which is something that you can do to start taking on more cases. Very quickly after that, I've applied for my CPS grade 2, which I'm waiting to hear back for. But again, everyone in Chambers is very quick and sweet and encouraging about putting you forward for things if they think that you can do it. And you do a lot of things that feel like, they're not what you thought you would be doing. And it's really exciting to be able to do it, but you feel very supported to do it. In terms of assessments, might be something that some of you might be thinking about. I know that there are some chambers that don't assess you and some that do. We did, I think, sort of 6, 7, 8 assessments. The first one, or maybe the first 2, are unassessed. And what that means is it just settles you into the process and gets you used to what it's like to have those. And then after that, they're assessed. And what that means is a member of Chambers will play the role of a judge or play the role of a witness and give you an exercise. And then you go in and do your best to pretend that it's not your colleague who you might spend, might go for a drink with afterwards. And you do the assessment. And it's, again, a great way of getting out those slightly awkward moments when you're first on your feet, where you feel a bit like you said the wrong thing, or you weren't quite sure about it, and it gets you into the habit of doing those things. And then you get feedback. And so it also means you can try out things that you don't really want to try out in court, but it helps you start to think about, your style and your advocacy and what type of advocacy you want to be doing, what type of advocate you want to be. So that's really helpful. And at the end, you do a mock trial where members of Chambers can come in and see you. And that's actually, because that's the last assessment that you do, it feels quite daunting, but it's really nice because people come in and support you, and it feels nice to sort of see everyone. In terms of, again, the mix of work, I know I've touched on that, but what I would say, as compared with, again, mates of mine who've done pupillage and have got tenancy elsewhere, I think doing a mix of work is exactly, my experience of doing a mix of work as a pupil has been exactly what others have suggested it would be, which is I find it really useful in learning advocacy. There are certain ways that you might approach something in a criminal case that actually really help you when you come to do a family case. If you're used to doing cross-examination in the criminal courts, then it's different in family courts, but there are still aspects to it that might help you frame the way that you approach things. And likewise, if you've been thinking about clinical negligence for a while and you've been thinking about how precisely to draft particulars of claim, for example, that might then inform a way that you draft an order, for example, and how precise you might be in a family order. So there are ways that doing that, having those overlapping practice areas is really helpful. From a financial perspective, it's also very useful when you're first on your feet, because some of the areas of law I'm particularly drawn to are probably the ones that are less well paid, I would say, or a bit more unstable, or even some of the pro bono work that I like to do. I feel like I can do more of that if I then occasionally do draft a contract advice or something that probably doesn't set the world alight for me personally, but actually means that I can balance those areas a bit better. I'd also say it makes you a bit more comfortable picking things up more quickly and at last notice, which is something that you will, at late notice, which is something you'll do as a pupil quite a lot. And one of the things you'll do outside of your pupillage is you will do an advocacy course, which is organised through your Inn of Court. And the way that works is they give you these exercises, they give you criminal exercises and they give you civil exercises. And I was quite surprised. This might be a cheeky thing to say when a number of you will be applying, I'm sure, to more specialist sets, but I was quite surprised when I did that at the number of people who usually do criminal work and therefore quite daunted by picking up something civil, and the number of people who usually do civil and daunted by picking up something criminal. And I felt that it's a real benefit to be able to pick things up and get to grips with them as quickly as you can. And I've personally really enjoyed that. I'm sure I've rattled on for quite a long time, but the last thing to say is that it is really a very supportive place in general, and it's a supportive way of doing pupillage. And it's completely true that you're not in competition with anyone else doing pupillage with you at the same time. In fact, my co-pupil and I would go for drinks, we'd chat, we'd check in with each other. How are you doing? I've got this piece of work, I don't really understand it. What would you do? And especially because we had sort of different interests and different backgrounds, it meant that we could complement one another and support one another, which was really helpful. And you really don't feel particularly daft for asking what probably, when you're starting out, are extremely daft questions. There are various WhatsApp groups with juniors where you can drop a message in and say, I've got this piece of work. I've never seen this word before in my life. I don't know what it means. Could someone point me in the right direction? Or particularly if you're in court and you have a judge asking you something and you're trying to get an answer and you say, oh, I'll just look that up. And then instead, actually, what you do is you WhatsApp a colleague because you know that they'll be able to get back to you quicker than you can look it up in Archbold or whatever it is. So yeah, everyone in Chambers is incredibly supportive. I've always felt like if there's a bit of a difficult day, you can find someone to go for a drink with. And people really do take the time to sit down and explain things to you. And my supervisors were always extremely happy to sit down and go through something with you. Especially I found my supervisor, who had the misfortune of watching me go on my feet for in April, was extremely supportive and encouraging about pushing you up that learning curve, which is it is a steep learning curve, but you have a huge amount of support to enable you to do it. I don't know if there's anything else, Rose, you'd like me to touch on. I know there's some questions that I've ignored. I'm very sorry. I can rattle through those if you want.
No, that's great, Jazz. Thanks. By the way, I'm sorry if there's any squeaking. I'm looking after our friend in Chambers. She's got this puppy and she's off on a trial today. So I've got the puppy and it's been biting my legs and I think it's now going to play with a squeaky toy. So sorry about that, if anyone can hear that. She lives down the road from me. But no, there are some questions, Jazz. Loads of questions have come in for you. Yeah. Can we save them to the end, if that's okay? Because we'll do it.
Yeah, absolutely.
And then everyone can kind of pile in on if they're the right person to answer them and stuff. So thanks for the questions, guys. I'm keeping a note and we'll come back to them at the end. The final, thank you, Jazz, for that. I think it's really helpful to have a kind of first-hand experience of someone who's just been through it in Chambers. So it's really useful to hear about it. And the other person who we're going to hear from before we go on to questions is Rahul. Sorry, Rahul. It's Rahul, who is also relatively new, but been a tenant now for a few years. And Rahul is going to particularly talk about coming to the bar as a second career, because Rahul, this is his second career. So he's going to talk about the kind of transfer and how that all works. So Rahul, can I hand over to you?
Yes, thanks, Rose. Hi, everyone. So as you've heard, I am a tenant in Chambers. I started pupillage at 7 in October 2020, so during the pandemic. And then I joined Chambers in October 2021 as a tenant, and I've just completed my first year as a fully fledged tenant. I have a mixed practice, so I do work across all of the areas of specialism in Chambers. By way of background, I initially trained as a solicitor at a Magic Circle firm here in London. I worked in commercial law. So I'm going to try and speak to you a little bit about my experience, my reasons for that decision, and then actually undertaking pupillage as a second career and now being at the bar as opposed to being a solicitor. So for me, I knew very early on, I studied law at university. I knew very early on that I was interested in contentious work rather than transactional work, which is, a big part of being a solicitor is whether you're doing transactional work or dispute work. I knew I always preferred dispute. And after qualifying, I joined a US firm and I specialized in litigation and arbitration with a particular focus in offshore energy. And I really enjoyed my work and I found it to be extremely rewarding, but there was a part of me that didn't feel completely fulfilled. I'd always wanted to be a barrister. At university, I'd enjoyed mooting, and it just so happened that I'd fallen into the very well-trodden path of becoming a solicitor after university. And I'd find myself sometimes being very frustrated working on a case with barristers, but finding that I was left to do a lot of the case management and a lot of the sort of less exciting tasks while they were driving the strategy and also doing the advocacy. So I tried to remedy that by getting higher rights of audience, and I became a solicitor advocate. But the reality is that doesn't get you access to the real quality work. And solicitor advocates, there are exceptions to this, but often clients will still want to instruct barristers or external counsel. So I still wasn't getting access to the work that I wanted to do. So it was a very big decision. I was doing well. I was establishing myself as a solicitor, but I just couldn't see myself doing that role for the rest of my career. And so I decided to make the jump. I had to start exploring options and start thinking about how I would go about things. One option would have been to transfer as a established practitioner, so not do pupillage. But because I had no real experience of advocacy, I felt that if I was going to make a success of myself at the bar, I had to do it properly. I had to come in, get the proper training and build strong foundations, rather than simply carrying myself across and hoping that I picked things up. The next part was choosing a set of chambers and deciding what area I wanted to practice in. And a lot of people probably think that a more natural choice would have been to go to a commercial set or choose a set of chambers that did the work I was already specializing in. But when I really thought about it, there were a lot of things that I didn't find very satisfying about that area of work. It was rewarding in some respects, but I'd find myself working on one or two big cases for 3 years. There wasn't a huge amount of variety, and it was quite tiring and frustrating. In addition, I think it's fair to say, and certainly I've got a lot of friends who practice at the bar in those areas, the opportunities for real advocacy are quite scarce. You're not in court very often. And, that was one of the main reasons I wanted to come to the bar. And I just thought I need something that will allow me to be in court and to develop as an advocate. And that's when I started to look into common law sets. I eventually came across 7 Bedford Row, 7BR. And what really jumped out to me, and this is a bit of a revelation, was that it's possible to have a mixed practice where you're doing civil work, but you're also then doing crime, commercial, family, employment. And for the first few years, it really is a bit of everything, as you've heard. Because of my training and my path to being a solicitor, I'd always been conditioned to think that you pick an area, you specialize in it, and that's that. But actually, that's quite counterintuitive. When you're sort of deciding what you want to do for the rest of your life, you need to have a flavor of everything. It will help you develop as a more rounded lawyer. And so, actually, I think the mixed practice makes a lot of sense. And what really amazes me, having now been at 7BR for a year as a tenant, and before that as a pupil, is that this set is involved in work in each area of discipline of the highest caliber. I'm sure you will, but if you have a browse on our website in the news area, you'll see that the number of members at all levels involved in leading cases in each discipline is enormous. And there's not many places that I can think of where you could have exposure to that sort of work in multiple areas at the same time. The big standout point for me, having now joined as a tenant and spent a year as a tenant, is that you're in court a hell of a lot. I'm in court at least 3 times a week, probably more. And when I think back to my first case, when I started in my second fix of pupillage, I remember how nervous I was because I'd never done any advocacy. I'd done mooting, but I was really nervous. And now it's just part and parcel of the job. And it really does just become second nature. Turnover of cases is really fast as well. So compared to what I was doing previously, where I'd have 1 case or 2 cases, which would sit on my desk for 2 or 3 years, now sometimes, you get instructed just to deal with a trial or a particular hearing, and then that will be your involvement. You're done. And then there'll be other cases where someone will come to you for initial advice, and then you'll see that case through every stage, through to conclusion. The mix works really well. It keeps things exciting. And having, done the opposite, where you just do a small number of cases for a number of years, I think I very much prefer the mix that I have at the moment. I think Rose touched on this earlier, but at some point it does become necessary to start thinking about narrowing your focus. Fortunately, I'm not at that stage yet. So for me, I'm still going along with everything that comes my way. And for those of you who may feel slightly conscious about undertaking pupillage and coming to the bar through the traditional route, having had a previous career, really all I can say is don't. Pupillage at Severn was extremely supportive, and it was very challenging doing it in the pandemic. But and generally, pupillage is not an easy year. But 7BR's focus was really to help me and my co-pupil develop and perform to our best. Our pupillage supervisors were never trying to catch us out, and although there is an element of assessment, and you'll always have, to be thinking that I am being assessed here, they were always happy to talk things through with me and guide me at a pace that works for me. I didn't feel like I was always being judged, and in fact, when I had appraisals and I had feedback where I'd made progress, or I'd learned something really new or been told something and then adopted that and implemented it in my work, that was what was really impressive to my pupillage supervisors. So they help you to grow. You've heard a lot about this, but Chambers really is a very supportive place, and it's not just your pupil supervisors. It will be any member who you come across, might even be people you don't know. It's a real community. As I think Jazz said, pupils are added to a WhatsApp group with just junior members of Chambers, and you really can just ask any question. There's no question that's stupid or too basic, free from judgment. And it's particularly helpful, as Jazz said, when you're in court and you're panicking because the judge is just asking something or something's come up. You don't know where to go. You try to Google it. You can't find anything. So you put a message in the WhatsApp and magically someone's got the answer. And as Kat said, you can call members of Chambers as well. It's not limited to WhatsApp. And in fact, I had to call her last night because I was really struggling with something. She really helped me out in about 10 minutes. So it really is a supportive place. For me, one of the particular aspects of pupillage that I was very anxious about was that I'd be practicing in areas that I'd only ever studied at university, like tort law and criminal law, or areas that I'd not done at all, such as employment and family. And because of my circumstances, because I had higher rights as a solicitor, I didn't even do the BPTC. So I think I can say this now. I really did feel like an imposter at times, waiting for people to uncover that I shouldn't really be here. But that didn't happen. And actually, having gone through that initial period, I can safely say that I didn't ever feel at a disadvantage. There is a lot of support, people are understanding, and you will be given every opportunity to do your best and to improve. And before I knew it, I was up and running, and I haven't really looked back. And in fact, I think the more I practice, I've started to realise that you get more confident with more experiences of dealing with unfamiliar areas of law or issues, and you stop coming across as someone who doesn't know what they're doing very quickly. And in fact, you soon realise that might be the real skill of being a barrister. So, yeah, I'm happy to answer any questions. If anybody has any for me, feel free to put them in the chat box, or I can answer them by email, or if they come through to Rose afterwards. But yeah, anything else, Rose, that you'd like me to talk about?
Rahul, thanks so much. It's one, I haven't seen you for ages, so it's really nice to see you. But two, thanks so much. It's useful to hear about how it's been going and how it is switching from another career. And I was just thinking, as you were talking, we've got quite a few members who I think come from all sorts of different backgrounds. We've got someone who used to be an actor, someone who used to be a nurse, who's now a silk, doing murder cases most of the time. We've got somebody who used to run their own business. And in terms of sort of coming at this from different angles, we've had pupils of all kinds of ages. I mean, we've fairly recently had a pupil who I think was in their 50s, or if not early 60s. We had, one of the ones I was just speaking about came when he was in his 30s. We've got pupils coming in their 40s. So I think a lot of people in Chambers, we've probably got a disproportionately high number of members who kind of come from different routes, I think. But we kind of, I think, would it be fair to say we kind of welcome them from both, Adam? I can see you're back. Thanks for joining us again. But am I right about that? Do we have a higher number than most, I think, in terms of other routes? Maybe it's because we offer quite a high number of pupillages. I'm not sure.
I couldn't answer that, let's be honest. I don't know what other sets do, but we certainly do have a lot of people who've done different things beforehand. I mean, one of our other silks was a classical guitarist before he became a barrister.
Yeah. So there's a massive mix, which is really nice.
Don't let anyone think that doesn't mean that we don't take lots of people who are coming through the conventional, because lots of people do it that way as well.
Yeah, and I think I was just thinking about our current 3 pupils. I think they largely have done a more conventional route, or if not, it's only been a couple of years before they've got to where they sort of then.
I think two came from law school and the conventional route, and one trained as a cardiology technician before doing law.
Yeah, there you go. So, it's a bit of a mix. That's just the 3 that we've got at the moment. So maybe gives you a good indication. So brilliant, Rahul, thanks so much. Right, so we'll move on to some Q&A. I've been trying to keep a note of the many questions that have been coming in. Thanks, guys, for engaging and listening and sending them in. It's really good to know that we can help, I suppose, and guide you a little bit about areas that you wanted to know a bit more about with Chambers. Some of the questions are quite specific for specific people, so I'm going to leave those off for now. But in terms of general questions, there have been a few questions about parental leave. Again, sorry for any noises that people can hear. The dog is now doing all sorts down there. He's very young still. So in terms of parental leave, people are asking what kind of policy we have. Do we support members coming sort of in and out of parental leave points? The
answer is we have a whole suite of parental leave policies. We certainly do support people both to take parental leave and other forms of career breaks. But remember, you're self-employed, so you're not going to get paid to do that. You will get rent rebates to do, or periods when you don't pay rent. But we're very keen to retain people who are becoming parents, to retain women who are having children particularly. And so we try and make the transition both in and out of practice as easy and as painless as possible.
What I would say about that, so my co-pupil Emily, who is a good friend, and Kitty, who's took tenancy, I think, the year after me, have both just had babies in the last sort of 6 months. Harry's probably crying because they're both family lawyers, so it's left him with a little dent in the team, but we're picking up the slack, aren't we, Harry? And both of them, I think, because we were sort of we were just chatting it through and what there is, but I understand, because they did some sort of comparison and research, that we have one of the best parental leave policies at the bar. It's newly written because we had a bit of a revamp with it. It was fairly decent before, but now it's really, really good. So there's discretion. I think it's something like up to 2 years of completely rent-free period with some checking in days, because we know that as a self-employed person, what you need is the opportunity to kind of maintain the relationships with solicitors and keep those links going. So it's really important to have that option without being made to pay, say, full rent again, because that's unrealistic. So it's things like that. And also then a period where I think there's a discretion for the head of Chambers to offer up to 7 years of half rent if people are only working part-time when they come back. So that's a really unusual policy that we have, which I don't think many other chambers do have. And the other thing that we have in our policy is about secondary carers. So obviously, might well be that obviously it's important as a primary carer to have the setup going and whatever, but we also have a policy that supports you as the secondary carer for a child. So if you take, I think it's you can have up to 2 months and things like that, even if you're the secondary carer. So I think we have an unusually supportive policy. And we also have a mentoring scheme for parents who take leave, or people who need time off for things like caring, where they can come back and be supported through that. And I think, again, this comes back to the relationship with clerks as much as anything. And I'm sure Harry would be able to comment on this, particularly given, as I say, he's got two of the more junior members kind of going through this at the moment. But I think keeping those links is really important, and keeping in touch with the clerks is really important, because one of the things that you don't know, I guess, as a parent is when, you might need a bit longer than you thought you'd need, or you might need less time, or, your plans can change, things need to be flexible. So there's scope in there for that. But I would say the good relationships we have with the clerks is one of the things that makes it a lot easier to be a parent and maintain a decent practice at 7. But Harry, how do you find that working with, members who have caring responsibilities? How does it work from the clerking's perspective to kind of manage that?
So yeah, obviously Kitty and Emily, who are sort of predominantly family, on their way back, let's say sometime next year.
Yeah.
I have conversations with them pretty regularly. I spoke to Kitty today, where we just formulated a bit of a plan for her return and rough idea of date. I think a sort of common worry could be from members maybe to think that they could be forgotten about for a period of time. But certainly here, the onus is that we keep the conversations going, Kitty and Emily have both been to various events or have joined Zoom talks and seminars, kept in touch with solicitors as and when they have felt they would like to. There's obviously no pressure from us, but I think it's just good that as a Chambers we keep those avenues open for people should they want them during their period with the children. So yeah, as a clerk being here, it makes it very easy. You know, we have the dialogue's always open. It's always welcome to join us with anything we're doing. And I think we have, they're called Cat's Day or Kids Days, Keeping in Touch Days.
Yeah.
Which I'd never come across before. And I think it's a really good way of easing people back in, because I imagine the last thing anyone would want to do is to step straight into a huge trial when you want to sort of find your feet and get back into the swing of things. And I think those, I'm not sure how many days they are, Rose, but there's quite a nice number of days where you can do that.
Yeah, I think it's something like one a week for a year's worth or something like that, just because the reality is, you know, what you don't want is if you do 1 day a week, you've got to pay your full rent again and pay your full percentage as a self-employed person. But we're quite realistic about that. So, yeah, I'd agree that it's, you know, and not having done it, but knowing from the others, I think that's probably quite helpful. But equally, you know, there's people like Kirsty who, you know, checked out altogether, and that's fine too, when she had her baby. So there's different ways of doing it. And I think we're just kind of, I think we're quite open as a Chambers about that. All right, thanks, Harry. That's really helpful. I'm going to move on to the next topic because there were quite a few about that. But the other thing that we've had quite a few questions about are how we organise the pupillage year, and to what extent people have a choice over things like location of their practice and the 3 areas of practice. Adam, I know you touched on this at the start of the talk. Maybe 1 or 2 people missed that. And what Adam was saying was that the first seat is always a civil seat because it's such a big part of Chambers work. And the second is always criminal work. And I think also, as everyone has said, you know, they offer you quite different advocacy experiences and skill sets. So they're both really core areas that it's really crucial to do from our perspective as a junior. But then when it comes to the third area, there is a lot more choice. But Adam, you organise that side of it. How do you find it when you need to organise that third area?
So, as you say, civil and criminal, but also with some family, so that when you're on your feet, you've got some experience of all core areas. And then I will speak to each pupil, see what they're interested in, and try and find a pupil supervisor who can meet that interest. Now, there's obviously, it's a bit of a mix and match, but we do our best to accommodate, to ensure that you're with someone who is doing the kind of work you haven't seen and you would like to see across Chambers practice areas. And we can kind of, so last year, we had someone with almost 2 pupil supervisors, both of them were doing employment, to make sure that person saw enough of that area of law. And I think, Jasmine, you wanted a full family seat in your last 4, so you were with Susanna. So we try as much as we can to accommodate, to make sure that people see what they're interested in.
Yeah, and I think the other thing to say about that is we add on, you know, you're not just with your supervisor. So you will go off with other members of Chambers. So one of our pupils is currently really interested in quarter protection, but her supervisor doesn't do that area. So she's been doing some stuff with me and I think other members who do quarter protection work, so that she's sort of seeing more of that area too. So we kind of incorporate those interests, I think, throughout. But as Adam says, particularly in terms of that last 4 months. And just in terms of... Oh, sorry, Jazz.
Sorry, Rose. Can I add to that it doesn't feel at all like a pupil that you can't sort of shout out and say, actually, there are a couple of, I feel like I'm noticing a couple of gaps, and actually, do you mind if, you know, is there a way for me to plug them? And you can certainly approach someone and say, actually, I'm realizing I haven't seen X, Y, and Z thing, and I'm either coming up to the point at which I'll be on my feet, or I'm coming up to tenancy. And or even, you know, what happened for me is I had an employment tribunal go into my diary that I'd never really seen before. So I sort of asked around and went to the clerks and said I would really love if I could just put aside a day before then so that I can see it and feel like I've at least seen it once before I'm on my feet. So you can also make sure that as you start getting work in your own right, you can fit in that those opportunities to shadow as well. And no one seems to No one seemed to mind at all.
The other aspect of that question, Rose, was
Location.
And the answer to location is we work all over the country. And certainly in your second six, you will be required to travel a lot. And as a junior tenant, you will be required to travel a lot. And although traveling has been reduced by the pandemic, I still travel a lot. And so if, you are one of the things we want to make sure is that people will be capable of getting up and getting on the early train to Lincoln, Doncaster, Leicester, Nottingham. I don't know Kat and Gareth, where are you now? Where's your trial at present?
They're on mute, but they're in Gloucester.
So, and I was in Southampton this morning on the early train. So it is a full English and Welsh practice.
Yeah, we can accommodate if somebody has, disability issues in that sense. And we have a member who did pupillage under 10 years ago, I can't remember how, maybe 8 years ago, who does have limited mobility. And so adjustments were made for that. And of course, we can accommodate those sorts of things. But the reality is that I think as a barrister and as being self-employed, there is always a degree of travel, whatever chambers you go to. With us, we probably have slightly more than some of the London sets. So, unless it's not viable, in which case, of course, we make allowances for that and we work around you. There is a good degree of travel. I think once you're a tenant, there's more choice about that. Many people do continue to do lots of travel, but there are people who limit their areas, and particularly when they've, say, got young children, they'll say, right, I'm going to stay closer to home or whatever else. So there is more flexibility the more senior you get with that. But as Adam says, he's a silk and he's traveling at this point in time. So it is still a live part of being a barrister wherever you work, I think. I can see somebody's asking about travel costs for pupils. It depends on the nature of the work. Obviously, with an award of £60,000, there's a degree to which, that will cover some of the travel that you do. But some cases you get your travel paid, some you don't. Sometimes chambers will cover certain aspects. But it's depends on the circumstances, but there is scope for that. But as I say, the award is very generous. So there is a degree to which if you're going for work or whatever, then it's covered. All right, so just moving on, because I'm conscious of the time. I don't want to take up everybody's entire Wednesday evening. Can I ask everybody on the panel maybe just to give their sort of one thing that they would say they look for if they're, say, reviewing applications? Because one of the key questions that comes up is sort of how can somebody make an impression with 7 Bedford Road? What can they look for there? So maybe, Adam, we can start with you and go through in order of when we spoke.
I think try and make your application evidence-based. It's very easy to use a lot of superlatives about yourself, but what we want is practical examples. So if you want to demonstrate that you have a particular skill, use evidence as an example to support what you say, because that's what we will look for. And to be frank, if you were applying for Silk or applying to be a judge or any of these, it's evidence-based. That's what we want, practical examples.
Thank you. Okay. And can I turn then, I think, to Gareth and Kat next? You guys got a tip each.
Yep, I thoroughly endorse what Adam just says there. Cut out, slash out any superlatives, adjectives, passionate about X and Y, put in real examples, keep it succinct, keep it punchy, because that's good examples of how you're going to be an excellent future drafter of legal arguments and the like. And also tailor it as much as you can to what we offer as a chamber, what you've been listening about for over an hour and a half now, the breadth of our practice and the like, because it will show that you've not just put us in as add us in as a 6th or 7th choice. You really thought about why you and your background and your skills would fit well with us.
And when it comes to you can tailor your pupillage portal application, I think, with certain questions, can't you? So really helpful advice. Kat, sorry, I interrupted you.
No, that's okay. Our Wi-Fi is letting us down here, so I'm sorry about the delay if you have one. I would say when it comes to our problem question, you can really stand out there because, again, that's something that is not going to be replicated across other chambers, and that's your chance to shine for us. So really take your time to research it properly and structure it properly and proofread it. So take your time over our problem question, because that's going to be a unique response for our chambers and unique to you. And we really do take our time marking that when it comes to looking at the applications.
Thanks, Kat. Let's turn next. Harry, what do you like best in barristers? What do you hope to see in people you're working with from the barrister side of things?
Sorry. I was actually dealing with an urgent call. So just as we said that we don't get those, someone's just been ringing for someone to go to court tomorrow on Friday. Best thing to look for in a barrister, I think I don't necessarily won't have that immediately, clear understanding of, when you find what you like, what you're passionate about, to convey that to the clerks. I think that's a huge part of what you do. Everyone wants to go to work and enjoy what they're doing. We're all going to have bad days, but I think as barristers, I think the more passionate you are about the work that you do and the different sort of niches within the different areas of law, I think that's what makes a great barrister, actually, is you following what you like and pursuing that. And if we don't know that, it's tricky to sort of guide the practice in that way. So for me, that's probably one of the biggest.
Brilliant, thank you. Jazz, should we come on to you?
Yeah, I mean, for candour, obviously, I've only just been taken on as a tenant, so I can only really speak from the experience of what do I think was in my application that had been commented on by members of Chambers who read my application since. And what I'd add a slightly different perspective to this, which is that I got pupillage on my third go, and I think one of the reasons for that was that I was very lucky to do that. One of the reasons was I'd been essentially a full-time carer at the time of doing my first couple of pupillage applications. And so one of the things that I struggled with was not necessarily having some of the more traditional types of pupillage candidate experience on my CV. And so because I was caring at the time, I couldn't do a lot of the mooting, or I couldn't really do as much of the sort of essay writing as others were doing, because I was caring and doing BPCC essentially overnight. And so what I found was that I think understanding where you've actually got the skills to do the job, and as Adam said, being really evidence-based in that, and not being afraid to think about what you've actually done and how that makes you a good barrister, and how that can demonstrate that you have the skills. Can you time manage? Can you deal with multiple demands on your time? Are you resilient? Can you pick things up last minute? And similarly to Rahul, I'd done different jobs before I came here, and so I relied quite heavily on work that I'd done and how I demonstrated those skills there. So I think not trying to be the typical pupil candidate, because of course all chambers will get applications that sound broadly pretty similar, and you are, as others have said, trying to stand out. And so just being self-aware about where your strengths lie and what they are, and I think not being afraid to really call on those experiences you have and articulate them in an evidence-based manner, I would say works for me. But different candidates are different, and of course those more traditional experiences are of course very important and very worthwhile. If you're an extremely pro mooter, definitely get it on your application, because that's a huge achievement. But there are other ways of demonstrating aptitude and experience as well, I would say.
Brilliant, thanks, Jazz. All right, Rahul, what about you?
So again, I'm still quite junior in Chambers, but last year I was involved in reviewing pupillage applications, doing the initial sift. So I'd say, at that stage, before you even get to it being considered for interview, etc., it's very important that you've understood exactly what the questions are asking you, and attention to detail isn't the tick in the box. It's something that really carries you through that first stage, because when we are marking pupillage applications or sifting through them and scoring them, which is part of the process, there's certain things that we're looking for. And if you've, copied and pasted an answer or not really spent enough time on the application, it's very easy to answer a question that wasn't asked, and that sadly doesn't get you any further along. And then the only other thing I'd add is, there's going to be a lot of applications that people are reading. If you can bring yours a little bit more to life in terms of your life experience, of course you have to focus on your credentials, qualifications, experience. But if there's something that you can add to give it a bit of flavour, that doesn't go amiss, I think.
Great, thanks, Rahul. And from my perspective, I would say quality over quantity. I'm a mentor in quite a few different schemes, and obviously I'm involved in the pupillage process in Chambers. And one thing I often see, I think, is sort of applications or CVs with 20 different things on them, which all make the same point. If you've done 12 minis, fine, great. I hope that helps you work out which areas you want to do. But it doesn't necessarily show me anything different than 3 might have done in terms of giving me the information I need to work out this is somebody who's interested in the bar and committed and has done some research. So I think pick your examples very carefully, and quality over quantity. You've got word limits, so make sure you really hone in and look at the mark schemes for various chambers. Our mark scheme and what we look for is on our website. It's the same for others. Use them when you're writing your application, because then you know what you're actually supposed to be trying to achieve with your answers. All right, well, guys, we don't have any more time for more questions, but thank you so much to everyone who stayed on the line. I can see we've got over 100 people, so really appreciate all of you showing an interest in Chambers. If you've got more questions, then please send them to us. You can send them to Chrissy using the email address that you did use to sign up. She'll pass those on to us. And some of us are on social media. I'm on Twitter, so if you've got other questions, you can direct message us or get in touch. We really hope this has been helpful for you, and we look forward to meeting you in the future and hopefully reading some of your applications. Have a good evening. Bye.